So good morning, everybody. We're just going to wait a minute for everybody to be able to log on, and then we'll get started. Okay, I think everybody has now logged on, so we'll go ahead and get started. Good morning. My name is Alan Lilly. I'm the presiding hearing officer for the State Water Resources Control Board's Administrative Hearings Office. Today is May 19, 2022, and it's just after 9 a.m. I am conducting this hearing on the administrative civil liability complaint that the State Water Board's Assistant Deputy Director for the Division of Water Rights Permitting and Enforcement Branch filed on February 18, 2022 against Griset Farms. When I refer to the AHO, I'm referring to the Administrative Hearings Office, and when I refer to ACL, I'm referring to administrative civil liability, just so you know. This hearing is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. You may post, or we will post an audio plus video file of this recording and the Zoom generated transcript to the Water Board's FTP site in the folder for this proceeding. You also can access the YouTube recording through the AHO's YouTube page, which you can access through the AHO's webpage on the State Water Board's website. Before we continue, I just want to check, has anybody ordered a court reporter for this proceeding? I don't see any court reporter, and I don't think anybody has. So just as a reminder, the Zoom audio plus video recording will be the official record of this proceeding. Zoom also generates a written transcript, which I would say has about 90% accuracy. So that's useful for parties to find where they are. If they want to find a particular passage in a recording, that will give them the hour, minute, and second. And it can be useful, but it is not the official recording because nobody has done any quality control on that. So even though we do not have a court reporter, still please try to wait until the last person has finished talking before you start talking. I will try to do the same thing. That will help us have a clear recording. If two people talk at the same time, the recording usually gets garbled. Now, if any of you have any technical difficulties, such as your screen freezes or you lose connection with this proceeding, I will try to notice that and call a recess, and we will then restart the proceeding when you can rejoin. You can try restarting your computer, and if necessary, you may call our office at 916-314-6940 and leave a message. All the staff who might answer that phone are working on this hearing today, so you'll have to leave a message, but we will try to monitor that. Or you can send an email to our office at our email address listed in the hearing notice, which is adminhrgoffice@waterboards.ca.gov, and we will try to work with you to correct any technical problems. Hopefully we won't have any. We've gotten this over the past 2 years. We've been doing these Zoom hearings. I think we've gotten the system, I won't say perfected, but certainly better than it was at the start. So during today's hearing, the AHO staff members who will be assisting me are Skylar Anderson, Kyle Wooldridge, Amy Blanc, and Nicole Mullen. And with that, I'm going to ask the parties or their representatives to identify themselves and their witnesses, and then we will proceed from there. So when I call on you, please take yourself off mute and state your name First of all, who is appearing today for the Division of Water Rights Prosecution Team?
Good morning, Mr. Lilly. My name is Debbie Orrs, and I am an attorney with Office of Enforcement and with representing the Division of Water Rights Prosecution Team alongside my colleague, Andrew Andrew, I'm blanking on how to pronounce your last name, Andrew. I'm sorry.
Go ahead, Mr. Turanian. Please pronounce your last name. It's a challenging one for all of us.
That's not a problem. Thank you, Mr. Lilly. I'm Andrew Tarianen of the Division, of the Office of Enforcement at the State Water Board. I'm representing the Division of Water Rights alongside Ms. Orrs today, and I'll let our witness, Mr. Cervantes, introduce himself.
All right, and Mr. Cervantes, please go ahead and introduce yourself.
All right, good morning, Mr. Lilly. My name is Robert Cervantes. I'm the Water Rights Enforcement Program Manager.
All right, is anybody else appearing today for the Division of Water Rights Prosecution Team? All right, thank you. And then who is appearing today for the respondent, Griset Farms?
Judge Lilly, I'm Paul Manassian. I'm an attorney, and I would ask you to inquire to make sure that Stephen Griset, a member of Griset Farms, is connected.
Okay, I saw a tile here. Mr. Griset, can you hear me? And if so, go off mute and make sure we can all hear you.
Yeah, I'm here.
Okay, you were briefly on video. We lost your video connection. Can you just try turning on your camera? There you go. Okay, now I can see you and hear you. So good morning, Mr. Griset. Can you hear us okay?
Yes, I can hear you fine.
All right, thank you. All right, and Mr. Manassian, is there anybody else appearing for the respondent today?
George Griset is another member of Griset Farms. George Griset is aged and he will not participate in the hearing, Judge.
Okay, I do not see any tile for him in the tiles on my display, but thank you for letting me know that. I'm just making a note of this. It's just try to keep track of everybody here. All right, is there anybody else who would like to participate in the hearing today? Okay, I don't hear any. I see several people who have logged in, and that's certainly fine. And please stay on mute. You can either log into the Zoom channel, as many of you have, or you can, if you want to, you can shift over to the YouTube recording and watch that. But if you're on and want to watch this way, that's certainly fine with me. All right, so I do want to discuss a few preliminary process points. As I said earlier, I will call on people to speak. If you can remember to stay on mute when you're not talking and then to go off mute when you are talking, that will help our recording. We sometimes have feedback problems if a lot of people besides me are off mute when they're not speaking. So, and of course, I'll remind you if you're speaking and you're on mute. We've all been doing this now for 2 years, but I think we all still sometimes get mixed up on mute and off mute. And if you want to say something and I'm not stopping to give you a chance, you can either just raise your hand the old-fashioned way, or you can click on it and electronically raise your hand. And I'll try to keep an eye on the displays so I can see if anyone wants to raise their hand and wants to speak. And I'll try to call on people as soon as I can when I notice that. Sometimes I have to finish a thought before I'll call on you, but I will try to do that as well. It's not quite the same as all being in person, but it does have the advantage for a lot of you that this saves a lot of travel time that you otherwise would have had to make to travel to Sacramento for an in-person hearing. All right, so I request that during the hearing you address me as Mr. Lilly, and that you refer to each other as Mr. with a person's last name or Miss with a person's last name. This is not a court proceeding, so please do not say Your Honor or Judge. I just go by Mr. Lilly, and that seems to work well, and I'll try to do the same when I'm addressing any of you. I've certainly worked with many of you over many years, but I think it's important that we keep this a little more formal and not go to a first name basis. I will ask Ms. Mullen of my office to post each exhibit through screen share as it's being discussed, and I will tell you she is superb at doing that. But sometimes it does take a minute particularly for large files, for them to upload. So if at any time you're asking questions of a witness and want us to post an exhibit or take one down and post a new one, just let me know, and I will ask Ms. Mullen to post the exhibit, and I'll try to maintain a record of what exhibit is up at any time. All right, are there any questions on the hearing process before we get started with the hearing itself? All right, hearing none, let's go ahead and get started. Because the prosecution team has the burden of proving its case, it will go first today. And I see from the written submittals here, the prosecution team just has one witness, so Mr. Cervantes. So Mr. Cervantes, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you will be giving in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Lilly,
Yes.
I prepared a very short opening statement. If now would be the right time.
That would be fine. Thank you for reminding me. I usually do allow opening statements. I usually allow 5 minutes maximum. So please go ahead. And then what we'll do, Mr. Manassian, if you want to give an opening statement, it usually works best if you wait and do that until the beginning of your case. So we'll go through Ms. Ore's open statement and then her witness and of course cross-examination. And then we'll shift to your opening statement and if you have any witnesses. So with that, Ms. Ore, you may proceed.
Thank you. Good morning, Mr. Lilly. As previously mentioned, my name is Debbie Ores, and I'm here representing the Division of Water Rights prosecution team. We are here today because respondent Griset Farms failed to submit its online curtailment certificate form as required by Section 875.6A of the California Code of Regulations. Respondent was issued a curtailment order on September 10th, 2021, and was required to submit its form by September 20th, 2021. To date, this form has yet to be submitted. Griset Farms is owned by Stephen Griset and has 2 water rights associated with the property. SG005923 and SG005924. Prosecution team witness Robert Cervantes will provide a brief summary of the enforcement process that has led us to this hearing. The hearing issues today are focused on whether a violation has occurred. Specifically, the sole issues at hand are whether a curtailment order was issued to the respondent, whether respondent was required to submit a online certificate form, whether respondent violated a State Water Board regulation or order, and whether this violation should result in penalties. The prosecution team answers these questions unequivocally in the affirmative. The facts to be discussed today leave no room for any other interpretation. Further, we stand by the modest penalty stated in the ACLC of $4,000, which is the equivalent of 4 days of violation per water right. There are no other issues, topics, or parties to be discussed today. Respondent has attempted numerous times to significantly expand the scope of this hearing. Respondent wishes to relitigate the question of whether the curtailment order applies to their water rights. Despite the fact that this argument was exhausted at the State Water Board when the order denying reconsideration was issued last month. This concludes prosecution team's opening statements. I will now hand this off to prosecution's witness, Mr. Cervantes.
Okay, in just a minute, Mr. Cervantes, before you get started, I neglected thank you, Ms. Ores, and I mentioned just a minute ago, Mr. Manassian, I'll give you an opportunity to present an opening statement at the beginning of your case. I forgot to mention a minute ago, what I'm going to do is we'll go through the evidence today, and then I will ask parties to prepare written closing briefs to submit after the end of the hearing. And at the end of the hearing, we'll discuss the appropriate deadline for submission of those. And then I know both of you attorneys, or all of you attorneys, are familiar with this, but for the other parties, what will happen then is after we get the closing briefs, we will prepare our proposed order under Water Code Section 1114, Subdivision C. We transmit that proposed order to the clerk of the board, and then the 5 board members will consider and decide what action they want to take on the proposed order. And when we do transmit that proposed order to the clerk of the board, we will transmit copies of it to everyone who's on the service list. And we also will post that on our AHO webpage. So with that, all right, I didn't mention that before. So, and actually, I'm sorry, I got a little bit ahead of myself. There are 2 other preliminary matters I wanted to talk about before we get to Mr. Cervantes. And I apologize, Ms. Ores and Ms. Cervantes, I got a little out of order here. The prosecution team filed a motion to quash on April 22nd, 2022, that related to a document request that the respondents had filed on April 14, I believe. And Megan Nyes in my office issued a written ruling on that motion, so we don't need to consider that further today. The ruling did take official notice of 4 documents, and some of these are also have been submitted as exhibits for this hearing. But I just wanted to state those documents were the State Water Board Resolution 2021-0029, which adopted the emergency regulations, the State Water Board Order WR 2021-0082-DWR, the State Water Board's Order WR 2022-0143 exec, which was the Executive Director's order denying respondents' petition for reconsideration. And then there was an addendum number 9 to Order WR 2021-0082, which was dated March 15, 2022. I'm not sure that is going to be relevant to this proceeding, but I just wanted to ask, does either party have any objections to my taking official notice of those water board actions as part of this proceeding?
No, Mr. Lilly.
On behalf of Griset Farms, there is no objection.
All right, thank you, Ms. Ores and Mr. Manassian, for that. Oh, and then the last preliminary matter, Mr. Manassian, you transmitted a subpoena to Mr. Eric Ekdahl, and Ms. Ores replied to the subpoena stating that the prosecution team was not legally able to contact Mr. Ekdahl because of separation of functions within the water board. And I responded that my office does not serve party subpoenas, and it's up to the parties to serve their own subpoenas. Have you decided to follow up with having the subpoena served on Mr. Ekdahl?
We've been unable to identify whether he was in the office and to serve it. In order to move forward, I believe that I can get at the issues that Mr. Ekdahl might have been able to testify to through Mr. Cervantes, but I will let the hearing officer know if there is any limitation on that. And in that case, I would request a continuance to allow his testimony, if relevant, to come in. I'm thinking that won't be necessary.
All right. Thank you, Mr. Manassian. I appreciate that clarification. And you certainly, I'm not going to remember probably. So if you think that's important toward the end of the hearing, make sure to bring that up.
I will, and I'll try to preserve the record on it.
Yeah, that's fine. All right. So Ms. Ores and the prosecution team uploaded exhibits PT 1 through 7 to the AHO's FTP upload folder. And after receiving those, my staff moved those exhibits over to the AHO FTP download folder, where they're accessible by all parties and everyone else who has a password to the AHO FTP folder. And Mr. Manassian, have you been able to download those prosecution team exhibits?
I have.
Okay, good. All right. So with that, I've given Mr. Cervantes the oath. And with that, Ms. Ores, I will allow you a maximum of 30 minutes for Mr. Cervantes to summarize his testimony, and you may proceed.
Thank you, Mr. Lilly.
Please proceed.
My name is Robert Cervantes. My testimony today supports the State Water Resources Control Board, Division of Water Rights recommendation to issue an administrative civil liability order against the respondent, Griset Farms. I am the program manager of the Water Rights Enforcement section and a licensed professional engineer. I have nearly 20 years of technical and regulatory experience related to water resource issues. I have been the Water Rights Enforcement Program Manager for approximately 2.5 years. In May of 2021, in response to California's historically dry hydrologic conditions, Governor Newsom declared a drought emergency in 41 counties, Siskiyou County being one of them. The drought emergency has since been expanded statewide, and California is still experiencing extreme drought conditions. On August 17, 2021, the State Water Board adopted emergency drought regulations for the Scott and Shasta River watersheds, both of which are major tributaries to the Klamath watershed. The Office of Administrative Law approved those regulations on August 30, 2021. The adopted regulations included curtailment authority for the Division of Water Rights. On September 10, 2021, the Deputy Director of the Division of Water Rights issued curtailment orders to diverters in the Shasta and Scott River watersheds. Respondent received the curtailment order through certified mail on September 17, 2021. On January 10, 2022, the division issued 138 notices of violation to diverters who failed to submit online certification forms as required by the curtailment order. Please note, this is a correction to what I stated in my written testimony on page 6, line 23, where I mistakenly stated we issued 60 notices of violation.
I just slow down just for a minute. I want to find, okay, that was line 23 on page 6.
Yes.
Okay, so I'm going to just make a note. You don't need to change the exhibit because the record will show, but you're basically saying that 60 should be changed to 138.
Yes.
All right. Thank you. You may proceed.
Thank you. On February 18, 2022, the division issued administrative civil liability complaints to 30 diverters who had still not submitted their certification forms. Respondent received the complaint through certified mail on February 22, 2022. The respondent has still not submitted his certification forms. The prosecution team considered all relevant circumstances, including the extent of harm caused by the violation, the nature and persistence of the violation, the length of time over which the violation occurred, in this case, at least 151 days, and any corrective action taken by the respondent. The prosecution team recommends that the State Water Board issue a penalty of $4,000, which is $2,000 per water right ID, This represents a 98% reduction from the statutory maximum penalty of $151,000. We believe our proposed penalty is the minimum amount to deter the respondent and similarly situated diverters from these types of violations while still being financially reasonable. It also considers the amount of time staff took to compel the respondent's compliance. Thank you for your time. This concludes my testimony, and I now offer my written testimony, PT1, and prosecution team exhibits PT2 through PT7 into the record.
All right, thank you, Mr. Cervantes. The way we normally handle exhibits is I accept the offers to have them admitted into evidence after all the questions have been completed, and then all parties can state objections. So Ms. Ores, please remind me if I forget, but after we've completed all the questioning, you may offer these PT exhibits into evidence. And of course, Mr. Manassian, you may object at that time.
Thank you, Mr. Lilly.
All right, so Mr. Manassian, do you have any cross-examination questions for Mr. Cervantes?
I do.
All right, and I can't remember what the notice says. I'm going to allow you 30 minutes. If at the end of, and I'll make a note, we're at 9:28 right now. If at the end of 30 minutes you think you need more time, I'll give you an opportunity to make an offer of proof of what additional topics you need to cover. But let's go with that, at least to begin with, as our time frame. So you may proceed.
Thank you. Mr. Cervantes, do you agree that on September 10, a letter was sent out, which is an exhibit to the prosecution team's package of exhibits on behalf of the State Water Resources Control Board?
And Mr. Manassian, would you like us to have me to ask Ms. Mullen to post so we can display exhibit PT3 so we have it on the screen?
Yes, I think that's going to be most helpful.
All right, so Ms. Mullen, please display exhibit PT3. I just find if we have them on the screen, it usually facilitates your questions and the witnesses' answers. So go ahead. We now have exhibit PT3 on the screen.
Thank you. Mr. Cervantes, do you see language in that document that was intended to inform water users that were listed on attachment A of what they should do?
Please, Ms. Mullen, show attachment A so I can better understand what Mr. Manassian is asking.
Yeah, we can go to, if you want, attachment A. Okay, that looks like, I've got the paper copy here, so it looks like it's PDF page 11. Okay, is this the page you want to look at, Mr. Cervantes?
No, it's the
Wait, excuse me, Mr. Manassian. Mr. Cervantes said, please scroll to attachment A. So that's why I'm asking him this question. Let him answer, and then you can follow up with your next question if you need to.
Yes, I believe that this satisfies what I was looking for. Appreciate it. Thank you.
Okay, so I'm not sure you've answered Mr. Manassian's question. So Mr. Manassian, why don't you either repeat or restate your question now?
Is there a list of the names of water right holders that the letter of September 10 was sent to Mr. Cervantes as part of exhibit attachment A?
I still do not understand the nature of your question, Mr. Manassian.
Okay. Is there a list of names of water right holders that was part of the September 10 communication that contains the names of the Grisets?
If I'm understanding your question correctly, I believe there is a list of curtailed water users on our webpage.
And was it also attached to the September 10 communication?
I don't know.
Okay. I think the next page, after 2 pages more, Ms. Mullins will give the list of names and water rights.
We'll go forward and scroll down. So I think I might be able to help us cut through this, Mr. Manassian, and I'm not trying to tell you how to ask your questions. Trust me, you obviously know what you're doing, but I was confused about this too when I was reading these exhibits last night. So, Ms. Mullen, would you please post exhibit respondent 1? And I'm going to just say, I think we might be able to make this go a little faster. Mr. Cervantes, I see this exhibit as the same order, order WR 2021-0082-GWR that was included with the letter that's exhibit PT3. But Ms. Mullen, go ahead and scroll down now in this one to PDF page 7. And this is where I'm confused, and I'm hoping, Mr. Cervantes, you can help explain what's going on here, because this copy of the order, excuse me, Ms. Mullen, please just scroll up 2 pages to PDF page 5. This version of the order has the attachment A form. Okay, now scroll down to page 6. And now to page 7. The attachment A form is blank, and then pages 7 through 10 have a list of numerous water right IDs, what they call primary owners and priority dates. Are you familiar with this list that apparently was part of this order?
I am not, no.
Okay, so that's going to be a problem for, I was wondering about that too. So Mr. Manassian, that's where we are. I am aware of this list because I read it when I was reading your exhibits yesterday. But you'll have to proceed and ask questions as you can, understanding what the witness knows and what the witness doesn't know. So Mr. Manassian, you may proceed.
Mr. Lilly?
Or Ms. Horace, go ahead.
If I may, I believe I can explain the difference between the 2 exhibits.
Okay, well, I'll let you explain it, even though you're not under oath, just to try to facilitate the process. Please go ahead and give your explanation, and then I'm going to shift back to Mr. Manassian and let him ask questions. So go ahead.
So if you go to the first page of respondent 1, you'll see that, well, I'll wait.
All right, well, Ms. Mullen, go ahead and scroll to the first page of respondent 1, okay?
So as you can see in the line, it says, in the matter of water rights and attachment of primary owner. This is a generic order. It is not the order that it was specifically sent to the respondent. Whereas PT3, instead of primary owner, it says Stephen David Griset. So the difference is one was a generic that was kind of the template form that was part of the original curtailment order, and one was sent specifically to the respondent.
Okay, and I do see, thank you, Ms. Orich, for that clarification. I do see in exhibit PT3 on PDF page 7 that the title of the order, instead of saying of primary owner, the way this respondents 1, page 1 says, it's in the title says attachment A of Stephen David Griset. So that appears to be the only difference in the text of the 2 orders, but then obviously there's the attachments to respondents 1, then there's no similar attachment to PT3. So Mr. Manassian, that's where we are. You may go ahead and ask your questions. And again, I do understand Ms. Orez is not under oath, but she is an attorney, and I don't have any reason to doubt the explanation she just gave. So please proceed with your questioning.
Thank you. Mr. Cervantes, do you know how the names Griset in the first 4 entries of the list got added to the list?
Okay, so
Objection, relevance.
Excuse me, Mr. Manassian, would you like us to scroll to page 7 of this exhibit P of respondents 1, so which has the list? I think that might help your question.
I'd be glad if Mr. Cervantes needs to, but I'm trying to conserve my time and roughly
Okay.
30 minutes.
Well, you can remind me at the end of 30 minutes that I've interrupted you a lot. So
Right.
Ms. Mullen, please go to page 7. And then now, Mr. Manassian, go ahead and ask your question. It's going to help me follow it anyway.
Mr. Cervantes, to repeat the question, do you know how the 4 Griset names got entered on this list?
No.
Okay.
Enforcement staff was not involved in the process of identifying water users for curtailment. The division's regulation staff used Siskiyou County assessor parcel maps and Department of Water Resources well log database entries to identify property owners for curtailment issuance.
If I stated and informed you that there are approximately 1,400 deep wells in the Shasta River Basin, could you explain to me why the names of other deep well owners do not show up on this list?
No.
Do you have any information as to how the identification numbers, SG, and then numerals were affixed to the Griset names?
I know generally the SG water right designation was developed specifically for the Scott and Shasta curtailment effort. So water users that were not in our ERIMS database with a standard water right prefix such as S0 or A0 were designated an SG prefix that stands for Scott or Shasta groundwater.
Do you know why the priority date was not filled in adjacent to the Griset entries?
No. I do know that priority dates for wells were assigned on best available data as to their construction.
Mr. Cervantes, there have been threats that there would be a filing for monetary sanctions against George Griset, and yet the notice of this hearing refers to Griset Farms. Can you tell us about your state of mind in issuing the notice for hearing in this case against Griset Farms as to whether or not it included all of the operations of the Grisets, both Steve and George?
Based on my understanding of the curtailed water users, Stephen Griset and Griset Farms must have shown up on an assessor parcel map from Siskiyou County or the Department of Water Resources well log database. Stephen Griset must have shown up as a agent or officer of Griset Farms, so we used them interchangeably.
Good. And so when we are holding a hearing today regarding Griset Farms, would you describe it as fair and equitable to treat that as resolving questions both as to George, Stephen, and the various entities that hold lands in the Griset holdings?
Objection, relevance.
I'm going to overrule that objection. I think this is important context. And I will note that Water Code section 1055.3, which concerns the amount of civil penalties, says the board will consider all relevant circumstances. And there's going to be some limitation to how far I will allow this line of questioning, but I think certainly the question of why the prosecution team seems to be proceeding against Griset Farms and not George Griset is relevant within the scope of that. So I'm going to overrule the objection. Mr. Cervantes, you may ask the question, and if you don't remember it, Mr. Manassian will repeat it for you.
Yes, please, Mr. Manassian, repeat the question.
I'll certainly try, and it probably will be phrased a bit differently. In bringing this proceeding by your division, were you intending to determine whether or not Griset Farms, which is a name that applies to both George and Stephen, had violated some order of the state board? Or were you trying to decide only if Stephen Griset had violated some order?
Objection assumes facts, not an evidence. There's no evidence that George is associated with the name Griset Farms.
Okay, I'm going to sustain that objection. I think, Mr. Manassian, you can probably avoid this problem if you can split up. That was kind of a compound question.
Yeah,
Why don't you
it was. Let me
split it into pieces, and I think that may help us all here.
Mr. Cervantes, in bringing this proceeding against Griset Farms, did you intend that the question of whether the compliance orders applied and had been complied with by Griset Farms, including George Griset, be resolved?
I'm going to do my best at answering what I think you're asking. Stephen Griset has two unique water right IDs. Based on the information that enforcement staff received from the regulation development team, Stephen Griset and Griset Farms were used interchangeably because Stephen Griset is an officer of Griset Farms. So we took enforcement action, this action today, on the two unique water right IDs held by Stephen David Griset.
Mr. Cervantes, you'd agree that you don't know whether or not Stephen Griset is the owner or operator of the wells that somebody assigned those numbers that are adjacent to Stephen's name to. Is that correct?
I need you to repeat that question.
Yeah, you're not here today with any knowledge of whether the wells that are identified by those numbers are owned by Stephen, by George, or by Griset Farms, or some combination, are you?
My understanding is that the two unique water right IDs assigned to Stephen Griset, officer of Griset Farms, are owned and operated by Stephen David Griset, or at least exist on the property owned by Stephen David Griset.
Let's go back to the September 10 letter that was sent to the Grisets.
I think it would be good if we display that. Is that PT3, I believe? Yes, Ms. Mullen, please put up exhibit PT3. I think, Mr. Manassian, this is the one you're asking about.
And particularly page 3.
Okay, so we'll scroll to page 3. Go ahead.
Okay. Mr. Cervantes, did you have a role in drafting the contents of this letter?
No.
Okay. Was this letter sent to the persons on the list for a particular purpose?
This appears to be the curtailment order. So
Actually,
yes.
Look at the top. It's September 10, 2021. it's an explanation of the curtailment order, is it not?
Wait, Mr. Manassian, I'm going to object to that question and ask you to
Okay.
rephrase it. I mean, the letter, we can all read the letter.
Yeah.
And I don't know that it's that useful to ask him to characterize it a certain way. I think you have to ask him a more specific question about something in the letter if you want to, but trust me, I can read the letter as well as you can. And we know Mr. Cervantes has testified it was sent to Mr. Griset. So I think you may have to either adjust your line of questioning or go to a different line of questioning.
Okay, look at the bottom of page 3, Mr. Cervantes.
Okay, so Ms. Mullen, please scroll down to the bottom of this page 3 of Exhibit PT3. All right, we've got that. So now ask your question about this, Mr. Manassian.
We're on the I guess we'll have to go to the next page. I'm sorry.
Okay, we can scroll to page 4.
Look at the language in the second paragraph. This curtailment order does not extend to overlying groundwater users in the Shasta River watershed. Do you see that language, Mr. Cervantes?
No.
Okay, Mr. Cervantes, it's the first full paragraph, second sentence. So if you go from the top of the page, it's down about line 6 is where the sentence that Mr. Manassian read starts.
Okay, I see that.
Okay, go ahead, Mr. Manassian.
Did you have an understanding of what was required of overlying groundwater users in the Shasta River watershed as a result of receiving this letter of September 10?
Objection, relevance?
I'm going to overrule that objection. Go ahead, you may answer the question.
So my understanding is that overlying diverters extract water from wells on their property and use that water on their property that's within the same overlying groundwater basin.
And my question was, as a result of receiving this letter, what was an overlying groundwater user supposed to do, if anything?
My understanding is that if I was a reasonable overlying groundwater user and I received a letter from a state agency that I didn't quite understand, I would contact that agency to obtain further information.
And do you agree that the Grisets filed a request for reconsideration with the state board within the 10-day period of receiving the notice through the September 10 letter?
I do understand that the respondent filed a petition for reconsideration. I don't know if they did it within the 10 days required, but I do believe that they submitted that petition and that later got rejected. Yes.
Okay, so my question to you is, what were the Grisets supposed to do other than ask for clarification of what was to happen as a result of the compliance order and the request that they do something on the internet?
Objection asked and answered.
Overruled. You may go ahead and answer the question, Mr. Cervantes.
The order states that the diverters are supposed to cease diversions until It says they're supposed to cease diversions, and the respondent submitted a petition for reconsideration. Petitions for reconsideration do not stay curtailment orders. So the respondent should have ceased diversions.
Let's look again at this sentence. This curtailment order does not extend to overlying groundwater users in the Shasta River watershed. Isn't it true that if the order doesn't extend to overlying uses of groundwater, there is nothing for the particular landowner to do as a result?
Argumentative and misstates evidence.
Yes,
Right, but excuse me. Wait, Mr. Manassian, I'm going to sustain the objection. I think I can help us all out here. But Mr. Cervantes, I'm going to just ask you hypothetically, if either Griset Farms or Stephen Griset, whoever the property owner was, and I'm not saying these are the facts, but if hypothetically the facts were, he was just pumping groundwater and using it to irrigate crops on his parcel, and that overlies the same basin from which he pumped the groundwater, what was he still supposed to file a curtailment certification notice or not?
Yes, all diverters who received the curtailment order were supposed to submit the online curtailment certification form.
All right, Mr. Manassian, you may proceed.
Mr. Cervantes, would you agree that there is no portion of this September 10 letter that explains that to the reader?
I do not agree with that. I'd need to read the letter in its entirety
Why
before I could
don't you point to the language
point to the language that what?
that says an overlying groundwater user must either curtail use or must file something on the internet for the state board?
Okay, I do not have the entire letter in front of me. It sounds like you may know where in this letter it says that. Can you point me in that direction?
It doesn't exist, Mr. Cervantes. That's my point.
Okay, and Mr. Manassian, this is certainly a very important point, and you can make this in your closing brief. I'm not sure it's going to be more. I mean, I think Mr. Cervantes has said he is not aware of any such language in this letter. And of course, I can read your closing brief and I can read this letter again. So I think you've made your point.
Good. Mr. Cervantes, let's go on to the blackened or emphasized sentence that says selling groundwater hauled and used at a different location is an appropriate use and must cease immediately, subject to exceptions described below if the use started after November 1912. Do you see that language?
Yes.
Was that language included in the state board's emergency order?
I don't know. You mean the emergency regulations?
Yes.
I don't know offhand. I will say that, being that the enforcement section did not draft these curtailment orders, the curtailment orders were drafted with authority from those emergency regulations.
Okay, so I'll address this to Mr. Lilly in the closing brief. But did anybody provide you with information that you should add on the internet site some sort of question that a pumper of overlying groundwater should answer as to whether they were receiving compensation for the groundwater that might be transported by a pipe or a truck to another parcel of land.
Objection asked and answered and relevance. Mr. Cervantes has already testified that he was not involved in the drafting of the curtailment order or how people were added and identified as part of the curtailment order.
Yeah, I'm going to sustain that objection. Mr. Manassian, I think you're getting into it. I don't think it was asked and answered, but all of a sudden you're asking about whether a form was asked about compensation. I'm not clear of what your line of questioning is here. It might be better if you just ask him. One thing I've been wondering about is, can he provide a copy of the form that they were supposed to fill out? And then we could all look at it and see what it asks and what it doesn't ask. I think that might be a lot more efficient here.
I have that form, but I do not have the capacity to put it up on the screen for you. I can fax it to you or do whatever you want, but there is no place for entry of someone who says, I'm an overlying groundwater user and I'm extending that water to other overlying users adjacent to my property.
Okay, here's what I suggest we do. Mr. Manassian, do you have staff available who can scan that form and email it to us? Because we can then mark it as an exhibit and we can put it up on the screen. I just think it's going to be a lot easier for you and Mr. Cervantes and Ms. Ores for that matter, if we have the document on the screen. Ms. Ores, your hand is up. Go ahead.
I believe we have staff who can pull that up pretty quickly, as they have access to the website and they can. So I would, ask Mr. Cervantes or another staff member, Mr. Lang, who's on this call, if they believe they can pull that up quite quickly.
Okay, let's go ahead and do this. We've been going for an hour. It wouldn't hurt to have a short break now anyway. And Mr. Manassian, do you have staff who can do that scanning and emailing as well?
I can. Can I get the email address that you want it sent to?
Yeah, and so I'd like you both to email it to me. You're different, just in case they're different. Then we'll mark those exhibits as exhibits and post them, and then we can go forward. So our email address is admin, ADMIN, then HRG, and then office, OFFICE, at waterboards.ca.gov. So do you have that, Mr. Manassian? It's also in our hearing notice, but that's our email address.
I've got it.
Okay, Ms. Ores, do you have that email address as well?
Yes.
All right, so please, both of you, get those emails to us as soon as you can. Scan the docs, or hopefully only a couple of pages, and email to us, and we'll post them. Let's plan to come back at 10:15. We will get those posted as soon as we can. I'm going to, since this is with Mr. Manassian's line of questioning, unless you have an objection, Mr. Manassian, I just have to give these some labeling. I'm going to just mark these as exhibits respondent 12 and respondent 13. All right, so we will do that, and then let's come back at 10:15. Hopefully, so check our upload folder around 10:10. We'll see if we've gotten them, and then we'll plan to come back at 10:15. So please don't log off, but you can certainly turn off your microphone and your camera, and we'll come back at 10:15. Thank you.
Thank you.
Just stand up. That's fine. Thanks.
Okay, hopefully everybody will come back here. We can get started again. Just waiting for Ms. Ores, and we'll get started. Okay, so let me tell you what I and my staff have done. First of all, we received an email from Ms. Ores, which had two files attached to it. The first one being the Scott-Shasta curtailment certification form for SG 005923, 3 pages. And then there was a ERIM survey form. Ms. Ores, what do you know why you sent us the ERIMS file as well?
Yes. I don't know why there's an echo. Because the respondent has 2 water rights, we were sending both of the ERIMs. So it shows that 24, the water right that ends with 24, the respondent never logged in. So we couldn't show the form for the respondent's second water right. This is the best that there is.
Okay, so Mr. Anderson or Mr. Woldridge, if you can, I previously asked you to merge them into one exhibit, but it's better to keep them separate. So I'll state for the record, the first form my staff has posted is exhibit PT8. I previously said we'd do it as a respondent's exhibit, but they pointed out it to avoid confusion since Ms. Ores submitted, it's better to have it be the PT exhibit. So that's PT8. And then Mr. Anderson or Mr. Woolwich, if you can just make that second file and post it as PT9, then we'll have both of those in the record. Meanwhile, while Ms. Ores was doing that, I received an email from Deborah Beth of Mr. Manassian's office, which transmitted the Shasta curtailment certification form for SG 005922, which looks like it's the number that was actually one of George Griset's SG numbers. It looks like it's a similar format. It's printed sideways, so it ends up taking 7 pages instead of 3. And Mr. Woldridge, while we're talking here, if you can, I know you're computer savvy here, if you can make a new PDF and just rotate those images so we can have them be displayed right side up instead of sideways, I would appreciate that, and we'll just repost that. But we have both of those up there now. I think, Mr. Manassian, the best, and I don't have any preference for who submitted what here, but I think from just a formatting point of view, if we use PT8, it's right side up already, and it's on fewer pages, and it's for SG 005923, which is the first of the water right IDs at issue in this hearing. So unless you have an objection to that, I'd ask that we have Ms. Mullen post PT8, and you can ask your questions about that. Is that an acceptable way to proceed for you?
That's acceptable. Thank you.
All right. So Ms. Mullen, please post exhibit PT8 on the screen, and we'll go to the first page. There we go. And now, Mr. Manassian, you may ask Mr. Cervantes your questions.
Mr. Cervantes, are you familiar with this compliance certification form?
I am somewhat familiar with it. I'm not intimately familiar, but I do know the generalities of the form.
Was there a place to enter information if you were an overlying groundwater user and you didn't intend to curtail water use on this form?
I don't know.
Thank you. Do you remember anybody encourage anybody, by that I mean anybody at the state board, staff, or anybody from the outside encouraging your department to bring a compliance order violation claim against Griset Farms, George and Steve Griset?
No.
Objection relevance.
I'm going to overrule the objection, and he already answered no. And Mr. Cervantes, it'd probably be good when Mr. Manassian asks questions, count to 3 before you answer, just in case your attorney
Sure.
wants to. State
Thanks
an
for that,
objection.
Mr. Lilly. Now I appreciate that. And that's my general rule, but this was a very easy question to answer. So I just got on with it.
Okay, so the objection is overruled. The answer no, it remains in the record. Mr. Manassian, you may continue.
Thank you. Mr. Cervantes, have you ever reviewed the order of the state board that led to the September 10 letter and the request that people do things, to see if the state board ordered any difference between somebody who pumped water on overlying land and charged for the water versus provided the water without charge?
So, Mr. Manassian, I'm going to ask you to restate the question. Board order is not clear here. We have a board resolution that adopted the regulations, and then we have the Division of Water Rights order that's included in PT3 and Respondents 1. So I want you to be clear which one of those two you're asking about.
I'll be glad to. Can we have a Respondent Exhibit 1, page 3, put up on the board?
Yes, Ms. Mullen, please display Respondent 1, page 3. Excuse me.
Mr. Lilly, may I have a time check, please?
I was wondering about that. We certainly are well over half an hour, but most of it's been consumed with my asking kind of mechanical questions. So I certainly am not going to tell Mr. Manassian he's done now. But Mr. Manassian, maybe we should check. How much more time do you think you have for your cross-examination questions for Mr. Cervantes?
I'm almost done with Mr. Cervantes, and I want a few minutes with Mr. Stephen Griset, and that's it. And by a few minutes, I mean about 10 minutes.
Okay, well, that'll be part of Respondent's case, so we'll get to that. First, I may have some questions for Mr. Cervantes, and then Ms. Orris may have redirect, and then we'll get to Mr. Griset. But
Okay.
yeah, so we're at 10:26 now. I'm going to give you till 10:40, which should be enough based on what you just said. But and then if we need more, we'll see where we are at that point. So please proceed. And for the record, we do have page 3 of Exhibit Respondent 1 on the screen now.
Mr. Cervantes, do you see paragraph 2 of this order that is to be effective on September 11, 2021?
Yes.
And do you see anywhere in paragraph 2 that it says that a overlying groundwater pumper who is listed on attachment A is not required to terminate groundwater pumping?
Paragraph 2 does not say any of what you just said.
Okay, and does paragraph 2 identify any difference between someone who pumps groundwater and uses it on overlying land, even if the overlying land is owned by someone else in the area?
I need a moment to read paragraph 2 in detail.
Certainly.
Okay. Please restate your question, Mr. Manassian.
Yeah. In bringing this claim that the Griset farms did something wrong, I'm asking you if what they did wrong is described in paragraph 2, which is that they pumped groundwater after they'd gotten the notice in some fashion that was prohibited by the state board's order.
Paragraph 2 states diversions under this water right may be permitted to continue only if authorized under an exception to curtailment as described by these water code sections. My understanding is that those exceptions are for human health and safety, minimum livestock watering, and non-consumptive uses like hydropower. So if you are a diverter and you're diverting for a purpose other than that, then that would be a violation.
So you understood that the Griset's name had been put on this list of groundwater users in some fashion prior to the issuance of this order, did you not?
My understanding is that Stephen Griset, the respondent in this hearing, was placed on the list as a groundwater appropriator.
Okay. And did you understand that not all groundwater users in the Shasta River Basin had been put on that list?
Objection. Assumes facts not in evidence. Also, Mr. Cervantes has already testified he was not part of the drafting of this order or who is subject to this order.
I'm going to sustain the objection. Excuse me, Mr. Manassian. I'm going to sustain the objection. Why don't you, I think you can rephrase the question in a non-argumentative way that'll get to your point. Just ask him whether he had an understanding about that or what his understanding was. I think it'll be a lot clearer for all of us.
What was your understanding, Mr. Cervantes, as to how this list of groundwater users had been attached to the state board's order?
My understanding is that the regulation development team used Siskiyou County assessor parcel maps, as well as Department of Water Resources well completion log database results to prepare the list of diverters to curtail.
And excuse me, Mr. Cervantes, I was writing fast and I missed something here. How did you describe what part of the State Water Board Division of Water Rights that was called? You said something team. I want to make sure I get the right words.
The regulation development team.
Okay, thank you.
It's it's
That's
a team
fine.
that's not enforcement staff.
Okay, thank you. Mr. Manassian, you may proceed.
Mr. Cervantes, you are a licensed engineer. Is that correct?
Yes.
And did you get a chance to look at Respondents 11, which is a groundwater study of the Shasta Basin? There are about 1,400 well profiles and completion records that were compiled in that study.
Objection, relevance.
Let's just ask the foundational question. Mr. Cervantes, have you reviewed Exhibit Respondents 11?
No.
Okay, I think that may take care. So with that, that objection is sustained. I don't know, Mr. Manassian, whether it makes much sense to ask him about respondent at 11 if he
I'll
hasn't
just
looked at
ask
it.
one follow-up question. Did you have any information that would lead you to believe that the Griset's wells were serving water through some mechanism to non-overlying lands of the Shasta River Basin?
Objection asked and answered. We've gone over this. Mr. Cervantes was not involved in the compilation of the list of groundwater or of water right users for the curtailment order.
No, I'm going to overrule that objection. I don't think this specific question has been asked. But you may answer the question if you know, Mr. Cervantes.
I need you to restate the question, Mr. Manassian.
And try to just repeat it, Mr. Manassian. Don't restate it, otherwise we might get another objection.
Mr. Cervantes, did you have any information available to you that would indicate that the Griset's wells were not pumping and using water on overlying lands at the time that you issued this complaint for fines?
I'm still not sure I understand your question.
Okay.
Did I have information for what?
Go ahead. Try again, Mr. Manassian.
That the
I think
Griset wells were not pumping water for use on overlying lands.
The information that we got for the respondent in this case was received from the regulation development team. So that's the best information that we have, and that's the information we used to determine if anybody that was curtailed responded to the curtailment order by submitting the online curtailment certification form. Respondent in this case, based on our records, did not.
Okay. And did I hear that there were about 168 people that didn't respond to the order?
We issued 138 notices of violation to folks that did not submit their online curtailment certification form, and we issued 30 ACLCs. That's an administrative civil liability complaint. Respondent in this case was just one of those 30.
Okay, so if my question is, how did you determine if you did? And it sounds like you didn't. So let me ask you this.
Excuse me, Mr. Manassian. Just ask your question. No editorial comments, please.
Did you make any determination before the complaint for fines was issued as to whether or not somebody was an overlying groundwater user?
No.
Good. I think that completes with this witness.
Okay, thank you, Mr. Manassian. So please all bear with me for just a moment. I try so hard to keep my papers organized and they end up being a mess. But let me just check my notes here and see if I have any follow-up questions.
Yeah, go ahead.
Okay, so Ms. Mullen, please display exhibit PT3 and scroll to page 6. All right, Mr. Cervantes, the first full paragraph on this page has a heading that says request for reconsideration. And the text reads, you may submit a petition within 30 days to request the State Water Board reconsider the enclosed order. And then it goes on to talk about that. Do you see that text?
Yes.
So hypothetically, if Mr. Stephen Griset had filed, or his attorney had filed a petition for reconsideration that had argued that his pumping was authorized by overlying rights and therefore was not subject to the order, do you know what the State Water Board would have done with that petition?
I cannot speculate as to what the water board would do, but I can say that my understanding is that petitions for reconsideration do not stay curtailment orders.
Okay, that's not really answering my question, but if you don't know what the State Water Board would have done, that's fine. I certainly don't want you to speculate. So let me just. So let me go to.
Mr. Lilly, you are aware that one of our exhibits is the petition for reconsideration and the response of the state board.
Yes, I am. So
Thank you.
and believe me, we'll have time to cover all of this. Let's go. Yes, if you can, Ms. Mullen, please scroll down to 2 pages to PDF page 8. And this is getting into the order itself. Okay, and go to paragraph 4. Just a minute here. So, Mr. Cervantes, in this paragraph 4, if you go down 1, 2, 3, 4, 5 lines, in about the middle of the row there's a sentence that starts to ensure that. Do you see that?
Yes.
Okay, and I'll just read it here. To ensure that the regulations drought emergency minimum flows are met, it is necessary to curtail all of the most junior water right holders in the Shasta River, described in section 875.5, subdivision B1A, and that says in brackets, appropriative surface and groundwater rights post adjudication, close bracket, as well as a portion of those water right holders in the priority group described in section 875.5, subdivision B1B, and then in brackets, Shasta adjudication, with priority dates later than November 1912. Do you see that?
Yes.
So is there anything in this paragraph or any of the other findings on the previous page or this page of the order that states whether or not Stephen Griset or Griset Farms pumping is within either the group described in subdivision B1A or the group described in B1B of this regulation?
I'm not sure I quite understand your question, Mr. Lilly.
Okay, well, my question is, this order is directed to Stephen David Griset. Is there any finding in this order that his well is subject to either of these parts of this regulation?
I believe in either attachment A or in the cover letter, perhaps. The respondent's water right ID is identified as an appropriative groundwater diversion subject to curtailment.
Okay, can you tell me, I'm not trying to be tricky here, but I did not see that in either the letter or attachment A, but if you can tell me where it says that, I would certainly like to know that. And if you
I
want,
don't
we
know.
can scroll up to the top of the first page of the exhibit where we start with the letter.
Sure, let's do that.
And if you want to have a moment to look at, I don't know if you have a paper copy or some other way to scroll through it than just on the screen, but if you do, that's fine as well. But Ms. Mullen, please go up to page 1 of PT3.
Okay, so just so you know, I'm looking at a copy on my computer right now. So just please give me a moment and I'll try to identify where it says the respondent's water right ID is subject to this curtailment.
Okay, yeah, please do. And when you have the page, just let me know and I'll ask Ms. Mullen to scroll to that.
Okay, so Mr. Lilly, would you please repeat your question to me?
Yes, my question is there anywhere in Exhibit PT3 where anything, and we'll cover both the transmittal letter and the order itself and the attachment, is there anything that ever says that Mr. Griset's water right ID is subject to curtailment under the criteria that are described in the letter and the order?
Yes, so I'm looking here on page 3 of 6, and it's item 4, paragraph 4. It specifically states Stephen David Griset or their agent or successor.
Wait. So what? Hold on. Let's scroll there so we're all on the same page, so to speak. So Ms. Mullen, please go to PDF page 9 and scroll down to paragraph 4. Is this where you were reading from?
It is, yes.
Okay, now please state your answer again. I just wanted to have it on the screen, so go ahead.
My answer is this is a place that specifically calls out Stephen David Griset as having the water right IDs being curtailed.
Okay. All right, thank you. And as far as you know, is that the only place in this document where it talks about Mr. Griset being subject to curtailment under
It
this
discusses
regulation?
the curtailment order and cover letter discuss the water right types that are subject to curtailment. Our records show that the respondent is an appropriative groundwater user, which is called out as being subject to curtailment in this order and cover letter.
Okay, and what, when you say your records show that he's an appropriate water user, what records are you talking about?
The record is the list that we received from the curtailment regulation development team.
Okay, and Ms. Mullen, please go ahead and put up exhibit respondent 1 and then go to page 7 of that. So, Mr. Cervantes, is this the list that you're talking about that you received from the regulation development team?
Yes.
All right. Okay, so I don't have any further questions for Mr. Cervantes. Ms. Ores, do you have any redirect questions following up on Mr. Manassian's questions or my questions?
Yes, we do. May I ask for just a 5-minute recess to confer with my team?
Yes, that's fine. So it's 10:48. Let's come back at 10:55. And again, please don't log off, but you may turn off your microphone and your camera. We'll be back at 10:55. Thank you.
Thank you.
Sue, I'm not going to get to that counseling session. This hearing's continuing. Okay. Sorry. Okay. Bye.
All right. It looks like we're all back. It's 10:55. So Ms. Ores, do you have any redirect questions you'd like to ask Mr. Cervantes?
Yes, I do.
All right, please proceed.
Mr. Cervantes, what is the violation that is the basis of the ACL complaint that we are discussing today?
The violation is a failure to submit an online curtailment certification form.
Is the question of whether or not respondent continued pumping or in fact curtailed an aspect of the ACLC?
No, in fact, the order says that even if you ceased diversions, you still need to respond to the curtailment order.
How did you and the enforcement team determine that Griset Farms was in violation of the curtailment order?
We pulled data from the online certification portal and reviewed all of the respondents or diverters that received curtailment orders and reviewed that data as to who submitted or completed a response. And for the folks that didn't, they received notices of violation and ACLCs from us.
Does one's type of water right, whether that is groundwater or a statement or surface water appropriation, factor into the decision of issuing an NOV or ACLC as part of this enforcement matter?
No.
Why not?
Because the issue at hand for us in this enforcement effort was whether or not the curtailed diverter submitted their online curtailment certification form, regardless of water right type.
Okay, moving on to the curtailment order itself. Were you involved in the drafting of the emergency regulations?
No.
Were you or any enforcement staff involved in the drafting of the curtailment order?
No.
Were you involved in the drafting of the transmittal letter that went out with the curtailment order?
No.
Were you involved in the compilation of water rights subject to the curtailment order?
No.
Who was involved in the drafting of the curtailment order?
It was the division's regulation development team.
Were they the same people who drafted the transmittal letter?
I believe so.
How about the water right list?
Yes, I believe they prepared that list as well.
Within your role as part of the enforcement team, did you or anyone on your team reanalyze as the basis or applicability of the order to the listed parties in the curtailment order to issuing enforcement?
No.
Is doing such an analysis part of general practice of enforcement proceedings, just in general?
For these types of violations that are more cut and dried in terms of, did somebody submit the required form or not, we generally do not take that additional analytical step.
What is your understanding for why specific people receive the curtailment order?
Can you rephrase that question?
Yes. Actually, I'll move on from that. Strike that. To your knowledge, does the curtailment order classify the respondent as an appropriative groundwater user?
Yes.
Does the division provide assistance to water users who have questions about letters they receive from the division?
Yes. In fact, out of the 138 notices of violation that we issued, approximately 100 people, just over 100 folks called and received one-on-one technical support.
Can we pull up PT3, please?
All right, Ms. Mullen, please display exhibit PT3.
Can we go to page 4? At the very bottom of page 4.
We'll scroll to page 4 and move to the bottom. Go ahead.
Keep going, please.
I'm sorry, I couldn't hear you. What?
I know, I think she's frozen.
Oh, no. Are you back?
No, this is perfect. Mr. Cervantes, can you read starting at if you at the end of line 1 of footnote 6?
If you have questions about whether your use is distributing, please call the State Water Board's Scott River and Shasta River drought phone message line at 916-327. Okay.
Thank you. Does that mean, or what would, did you or anyone that you're aware of receive a call from the respondent asking about the enforcement order or about the curtailment order?
Not to my knowledge.
Okay, I want to move on to George Griset. Are there separate water right IDs associated with George Griset?
Yes, George Griset has 2 unique water right IDs distinct from Stephen Griset's.
Did the division issue a separate NOV to those water right IDs associated with George Griset?
Yes.
Did the division send a separate ACLC to George Griset?
Yes.
Are you aware of any hearing requests made on behalf of George Griset?
No.
Do you know when or about when a hearing request for George should have been made by?
Sometime in early April. I don't remember offhand, but I want to say sometime in early April would have been the date.
Thank you. Does the division add parties who have not requested a hearing to an existing hearing request?
No.
Is there any reason that you can think of why George Griset would be part of this hearing?
No.
That's all my questions.
All right, Mr. Manassian, do you have any follow-up questions? And again, limited to the scope of what has been covered in my questions and Ms. Ora's redirect questions. You have to go off mute so we can hear you too. There we go.
Mr. Cervantes, this issue of Griset Farms, do you agree that this hearing is occurring in regard to Griset Farms?
No. This hearing is in reference to the 2 unique water right IDs issued to Stephen Griset, who is an officer of Griset Farms.
Did you ever send a notice to George Griset that he would have to make a separate request for hearing in order to be part of this hearing?
I'm not sure I understand your question.
Do you remember any communication from your office to George Griset indicating that to be part of this hearing and subject to this hearing, he would have to make a separate request for a hearing?
We issued an administrative civil liability to George Griset for his 2 unique water right IDs, and enclosed in that administrative civil liability complaint, it contained the instructions for how and when to request a hearing for George's unique water right IDs.
Do you intend to pursue a $4,000 fine from George Griset separate from Stephen Griset, and the pursuit of $4,000 from Stephen Griset?
We may.
Nothing further.
All right, thank you, Ms. Ores. Thank you, Mr. Manassian. So Ms. Ores, would you like to offer the prosecution team's exhibits into evidence?
Yes, I would.
All right, I have exhibits PT 1 through 7 that you previously submitted, and then PT 8 is the curtailment certification form that we talked about today, and PT 9 you briefly discussed as the ERIMS printout for the second water right ID. And I assume, Mr. Cervantes, just since you're under oath, can you confirm that PT 9 is in fact the, and if you want, we can put it up on the screen, but can you confirm that this is in fact the ERIMS printout, which shows that there was no login attempt for a water right ID SG005924?
Please put it up, Mr. Lilly. I'd like to see that.
Ms. Mullen, please display exhibit PT 9. Fair question, fair request, I should say. All right, so Mr. Cervantes, and I just want to clear this up. Ms. Ores said that this ERIMS printout shows that Mr. Griset never tried to log in to regarding this certificate. She's not under oath, so I'm just asking whether or not you can confirm that.
I can confirm it. It appears that this water right ID has never been logged into.
All right. With that, Ms. Ores, I assume you're offering exhibits PT 1 through PT 9?
Yes, I am.
And Mr. Manassian, do you have any objections to any of these exhibits coming into evidence?
No.
All right. They will all be received into evidence. And with that, we will move on to, first of all, I'll have to ask Ms. Ores, do you have any other witnesses that you would like to call for this hearing?
Not now. No.
Okay. All right, I understand. There potentially could be rebuttal. I understand that, but that's fine. All right, so as I said earlier, Mr. Manassian's office has uploaded exhibits respondent 1 through respondent 11, which we have posted. And then just today we posted respondent 12, which is, I'll just say, the horizontal or landscape format of the certification form. I think it's the same form as exhibit PT 8. And so we have those exhibits. We're ready to move on. And Mr. Manassian, I believe you said earlier that you intend to call Mr. Griset as a witness. Is that correct?
Could you swear him, please?
I will, but first of all, since I forgot with Ms. Ores, I'm going to try not to forget twice. Do you want to make a brief opening statement before your testimony begins? Before Mr. Griset's testimony begins.
I'd be glad to.
All right, you don't have to, but if you want to, 5 minutes maximum.
Yeah.
And please go ahead.
Obviously, the issue here is whether or not the state board has jurisdiction, or even whether it asserted jurisdiction over overlying groundwater users. The notice said overlying groundwater users were not subject to the order. Therefore, how can they be subject to some sort of fine for failing to go on an internet site and entering some sort of information? And when the judge has an opportunity to look at the form that they were supposed to enter something on, you will see that there is no entry possible for an overlying user. obviously, the law is pretty clear that the state board has no jurisdiction over overlying groundwater use. And it doesn't really matter whether or not you charge your neighbor for pumping costs or not, so long as the water is used on overlying lands. Finally, this is a great hullabaloo about fish. And there was a proper procedure for the state board staff to use if they wanted to protect the fish by curtailing groundwater, which overlying users of groundwater get curtailed correlatively. That is, everybody gets subject to the order, not specified parties added to a list and supplied with a number by bureaucrats. And the answer is pretty simple. There could have been a petition to expand the Shasta River adjudication, or there could have been a petition to establish a new adjudication. We went to a lot of trouble in the legislature to put together a inexpensive and rapid court adjudication of groundwater procedure. And it would have been relatively simple to apply for an interim order. If you believe at the state board that there was some need to reduce groundwater pumping in the basin and taking into account travel time, somehow that reduction would have helped the fish, an interim order can be entered in regard to such an adjudication. So we're right on the cusp of some very, very important issues, but they all center on the rule of law. To have an orderly society, you have to have legal principles that apply, whether you're an outsider from the Central Valley growing alfalfa in Siskiyou County, or whether you're helping your neighbors who are Hmongs that you don't like. The rules have to be the same. Enough said, Judge.
All right, thank you, Mr. Vanazian. So, Mr. Griset, good morning. Please raise your right hand. Just raise it. There we go. Do you swear or affirm under penalty of perjury that the testimony you will be giving during this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Vanazian, I'm going to give you 30 minutes for you to ask Mr. Griset questions. I assume that will be enough. You said, I think earlier, you thought it would be somewhat less than that. So
yes.
Please proceed.
Your name is Stephen Griset?
Yes.
Mr. Griset, what does the name Griset Farms mean?
It's just a title for our company. My dad incorporated it in the 1970s, and then it's just a technical name for a farm. It's not a big corporation by any means, just Linda and I.
How many acres do you own or lease in Siskiyou County?
Between my dad and I, we own close to 1,000 acres, and we cultivate. We can irrigate around close to 600.
And what do you grow on the 600 irrigated acres?
Alfalfa and grain hay primarily, and some sorghum, Sudan cross.
Is your father an active farmer?
No.
Okay. What's his age?
84, I believe.
And does he use a computer and go on the internet and make entries as a normal part of his day or week?
No, he's never used email once in his life.
Mr. Griset, there are 4 identification numbers that have been assigned to wells. Would you describe how many of those wells are actually active or pumping water during the time you've owned this ranch and operated it?
Yes, there's on my dad's property, there's one large well on a 40-acre parcel that's a mile away from where the water is distributed on the land. And that's one of his wells that is ID. The other well of his is ID is up close to Harry Cash Road, and it's a well that has basically it's abandoned. It has a 1-inch outlet, but it's never been used. It's been used spare. I just inquired again. It's been used sparingly. It was used for a short time over the last 40 years. But since we've been here, and it's never been, there's been not a drop of water come out of it, but it was curtailed nevertheless. Then there's a well on the ranch on an 80-acre parcel where we live that has 2 pivots that we irrigate about 45 acres with. And then that's one of my wells with my ID. And then there's another well on a 190-acre parcel that irrigates close to about 160 of that 190 acres. And all the 3 active wells, so there's 3 out of 4 that are actually used. One is completely abandoned and is non-functional and has never been functional for numbers of years. So 3 out of the 4 are used.
Mr. Griset, there is an organization called the Siskiyou County Flood Control Water Conservation District in Siskiyou County that is part of the sustainable groundwater planning effort, is there not?
Yes.
And do you follow its affairs fairly closely?
As close as I can, yes.
And there's a parcel of ground next to your property where your well is located and where you irrigate, which is called the Shasta Vista subdivision. Would you tell us about how many acres are in that subdivision?
I'm not positive how many acres. I know there's, well, if somebody has a calculator, there's about 1,600 2.5 acre lots. I think the lots range between 2, 3, 4 acres. 2.5 acres is a normal size.
Okay. Is that Shasta Vista subdivision have a different land characteristic in terms of being leveled or being farmed than your land?
Yeah, it's completely, well, where we farm, it's prime agricultural land. So it would be classified probably class 2. That land, all the land, as soon as you leave and get into the subdivision, would be as the lowest quality land possible for farming. And it's basically hilly, rock and sand and junipers, basically worthless land.
Did the Siskiyou County Flood Control Water Conservation District do a study to decide which land should be treated as overlying the Shasta groundwater basin?
I believe in 2017 they expanded the basin to include our ranch. We're on the extreme border of the Shasta Valley groundwater basin, and on the eastern edge, and it includes the Shasta Vista subdivision, all part of it that is west and south of A12. A portion of the Shasta Vista subdivision is east of A12, and that is outside of the boundaries of the basin.
Okay. And did we provide to the hearing officer a copy of that groundwater study done by Larry Walker and Associates for Siskiyou County Flood Control District?
Yes, I believe so.
So to the best of your knowledge, is the land next to you, which is within the Shasta Vista subdivision, overlying the same groundwater basin as your farming land?
Yeah, absolutely undeniable.
Now, is there a reason that those individual 2 and 3, 4 acre lots don't have wells punched into the same overlying basin or underlying basin?
Yeah, well, I've had multiple conversations with well drillers around here, Arlie Enlow and Lee Enlow. They would describe well drilling up there as the hardest place in the world to drill a well. This is from people who, especially Lee, who drilled he was an expert, drilled 1,000-foot wells in Hawaii through lava because he's an expert that type of drilling. So it's just drilling through solid rock. It's extremely difficult, takes twice as long as a normal well. And you're not guaranteed you're going to get water. And you might be drilling 500 feet. It's extremely expensive.
Sorry, I'm objecting just about asking relevance. Why is this relevant to this hearing?
And the objection is overruled. I think it is relevant because one of the defenses to the administrative civil liability complaint, and I'm not saying whether or not it's a valid defense, but I certainly think Mr. Manassian is entitled to present evidence to support the defense. But the defense he's presenting is that the pumping by Mr. Griset and Griset Farms was authorized by overlying rights, and which are treated differently under the emergency regulation. So again, I'm not making any predetermination on the legal issues, but I do think the evidence is relevant. So therefore, the objection is overruled.
Mr. Griset, was there, to the best of your knowledge, within Larry Walker Associates' study of the groundwater basin and the requested change in the boundaries of the groundwater basin, was there any notation of the existence of defined underground streams or rivers, to the best of your knowledge?
No.
Okay. Mr. Griset, at a time going back to about 2016, did some of the Hmong families request, when you had your irrigation system pressurized, did they request the opportunity to get water from your pressurized irrigation system to fill containers and truck tanks to take to their houses in the Shasta Vista subdivision?
Yes.
And did you grant that approval?
Yes.
Is there quite a controversy in Shasta County now, in the most recent years, about whether or not some of that water is being utilized for cannabis purposes?
Objection, relevance.
Yeah, Mr. Manassian, how is that relevant to this hearing?
There was an injunction put into effect on February 3rd by the United States District Court. We put it into, presented it for evidence. And it's mysterious to me that there is efforts being made to burden the Grisets in regard to their use of water, when the federal district court has enjoined all persons acting in concert with the county of Siskiyou from taking measures which would prevent water being available for human consumption by the Hmong families. We presented a copy of that. Now, the relevance, Your Honor, is I can't go much farther with this without knowing who brought this storm down upon the Grisets and why. And it's not really relevant because I believe that the storm is illegal and improper and there should be no fines. But
This was covered in the HO's order support.
Wait. Excuse me, Ms. Ores. I don't think Mr. Manassian, are you done with your response to my question as to why this is relevant? You don't need to keep going if you're done.
I think that's enough, Your Honor, Mr. Lilly. That's enough.
All right, thank you. So Mr. Manassian, I did see and read the order from the Eastern District of California, U.S. District Court for the Eastern District of California, which issued a preliminary injunction against some Siskiyou County officials that, at least during the dependency of the order or the effectiveness of the order, prohibited them from enforcing two or implementing two Siskiyou County ordinances. But first of all, you've not offered that as evidence. That was offered in your objection to the prosecution team's motion to quash.
It is
And-
one of our exhibits.
I don't think it's in the respondents exhibits. Oh wait, no, it is. Excuse me, it is respondents 9. So I read it before with the motion to quash. So I'm familiar with the order. But that order does not apply to the State Water Board. It applies to Siskiyou County officials. Certainly nothing in Mr. Cervantes' testimony has indicated that the State Water Board was motivated by any of those factors that are discussed in that order that apparently may have motivated the Siskiyou County officials. So I don't see the relevance here. I think what Mr. Griset testified up till now about where water pumped from his wells is being used is relevant. But as far as what third parties, they're an animus or, hostility toward the Grisets, I just don't see that that's relevant to this hearing. And I think you said you're not particularly sure whether this storm is relevant here or not. So unless you have any further showing, I'm going to sustain the objection and ask you to move on.
Your Honor, I don't want to give up on this. Mr.
Okay, well, tell me what you think is relevant and why. And remember, we have 5 specific hearing issues for this hearing.
Yeah. Bear in mind that the injunction applies to persons acting in concert with the county. Okay. And something got this going as to the Griset wells being specially listed on this notice as curtailed. That's as far as we need to go today.
All right. So I'm going to sustain the objection on relevance grounds. If you think, or somebody on your team thinks that someone at the State Water Board is acting in concert with county officials in a way that violates the injunction, the proper forum for bringing those arguments is the United States District Court, which issued the injunction. And obviously there are remedies if you think somebody has violated that injunction, but that's not this hearing. And I think this is too far removed from our hearing issues to be relevant here. So I'm going to sustain the objection and ask you to move on.
Mr. Griset, when you got this notice of September 10 in the form of a letter explaining what you were supposed to do, did you curtail and stop pumping water for completion of the crops that you had in the ground in September and October?
Objection relevance.
I'm going to
We already stated that the violation is not about whether or not he curtailed, it's whether or not he submitted his form. So whether or not he curtailed, whether or not he kept pumping is irrelevant. As Mr. Cervantes pointed out, even if you curtailed, you still had to submit a form.
And I'm going to overrule that objection. I agree with you, Ms. Ores. It does not appear to be relevant to the issue of whether or not he violated the order. But the issue number 5 is what is the appropriate amount of any civil penalties? And I think certainly, and one of the factors in Water Code section 1055.3 is corrective action. So I think it is relevant potentially. And again, I don't know how the ruling's going to all play out on this. I'm just trying to consider relevance at this point, but I think it's potentially relevant to issue 5. So I overrule the objection. And Mr. Griset, if you want, Mr. Manassian, try to just repeat the question. Don't change it, but just repeat the same question.
You were farming about 600 acres in September of 2021 and October 2021 when this notice of curtailment was received, Mr. Griset. Is that right?
Yes. Yeah, probably less than 600 at that point of the season. Yes.
Did you stop pumping groundwater for use
No.
on your crops?
No,
And when the injunction was issued by the federal court, did you permit the Hmong families to continue to receive water for use in their residences within the Shasta Vista subdivision?
yes.
Nothing further of the witness.
All right, thank you, Mr. Manassian. So Ms. Ores, do you have any cross-examination questions?
Yes, I do, Mr. Lilly.
All right, please proceed. And again, I'm putting 30-minute time limits on. I don't know whether you'll be exceeding that, but please proceed.
Mr. Lilly, are we able to pull up the regulations? I know they're not in the record, but I assume that would we be able to pull up language from the regulations? Is that possible?
Yes. I don't know whether Mr. Griset will know anything about it, but we'll put it on the screen and you can ask him. So Ms.
Yes.
Mullen, please go to the general folder for this proceeding. And there is a file which I think is called 2021-08-19 resolution number. And I think it's 2021-0029. So please see if you can pull that up. That's the resolution, and the regulations that were adopted by the resolution are included in that. Thank you. I try to not say this too often, but Ms. Mullen is really good at getting documents up on the screen fast. So thank you, Ms. Mullen. I certainly, as always, appreciate all your actions here. So Ms. Ores, what page would you like us to scroll to?
I'm asking more for the emergency regulations. I'm looking for 23 CCR 875.
Okay, I think that's probably about PDF page 25. So let's go to PDF page 25 and we'll see where we are. All right, why don't you scroll down just a little bit, Ms. Mullen? It may be a couple of pages later.
875.5.
Okay,
So
we have to go up. Okay, excuse me. So go up a little bit more. All right. Do you want that with Shasta River?
Yes.
Okay, so just, excuse me, for the record, I think this is PDF page 24 of this resolution, and it's subdivision B of the emergency regulation, section 875.5, and it's the section regarding the Shasta River. So with that, you may proceed with your question, Ms. Ores.
Okay, so looking at B1A, and let's see, 1, 2, 3, 4, 5. The fifth line at starting at 4. Mr. Griset, can you read starting at 4 the purposes?
Yeah, for the purposes of this article, an appropriative groundwater right is distinguished from an overlying groundwater right when a diverter, 1, does not own land overlying the basin, 2, owns overlying land but uses the water on non-overlying land, or 3, sells and distributes the water to another party.
Mr. Griset, do you sell water pumped from your property to other parties?
On occasion,
Do you distribute water to other parties that is pumped from your property?
if from a hose moving into a truck constitutes distributes, then yes.
Yeah,
I mean, if that's just distributing, the water's not, yeah, I think the truck distributes the water. I think the water goes from the hose into a truck.
yes,
And
yes.
it's still on my property.
Okay,
Well,
so
if you're putting, if you're putting water into a truck.
Wait, Mr. Ores, when I talk, please stop talking. We have to try to maintain some control over this proceeding. So I think, Mr. Griset, you can clarify this. Are there times when you pump water from your wells and it goes into water trucks and then the water trucks take that water somewhere else?
Yeah, they take it to the adjacent, subdivision.
All right, Ms. Ores, you may proceed.
Let's see. Can we pull up PT3, page 4 again?
All right, Ms. Mullen, please put up PT3 and
This is
go to
perfect.
page 4. All right,
So-
tell us where you want us to be on this page.
So we're looking at footnote 6 again. And can you read that to yourself, Mr. Griset? And let me know when you're done.
Yeah, basically, it says that if I had a question about distributing, that I should call Sacramento.
Did you call the Division of Water Rights to ask any questions about this curtailment order that you received?
No, because I didn't believe it had anything to do with me because my wells are not adjudicated. When I read the part about adjudication, I just knew that, and I affect the river. I knew that both these things were incorrect. And after discussing it with my attorney, we decided to just we went with the reconsideration because of the lack of facts.
Well, I mean, Mr. Griset, did you not just state that you do sell or distribute water to other parties off of your property?
Yeah, but that's not something.
Thank
that-
you.
Wait. Ms. Orris, if you ask a question, you have to let him answer it. So Mr. Griset, you may go ahead and answer.
She can, I got distracted. Could she please ask that again?
Okay, well, yeah, Ms. Orris, I think you do need to ask the question again and let him answer. So please repeat the question.
Sure. Did you not just a few moments ago state that you do sell or distribute sell and or distribute water pumped from your property to other parties not on your property?
And now you may
Yes.
answer.
Yes, I did say that, as do many other people around here at this right now as I look out my window.
Yeah.
All right, Ms. Orris, you may proceed.
Did you file a petition for reconsideration of the curtailment order?
Yes, immediately. I immediately contacted my attorney. Our option was for a reconsideration, and we believed that the reconsideration was going to be responded to within 90 days, and it was responded to with, I don't know, about 180 days. And that was our method of responding.
Did you, as part of your petition for reconsideration, ask for a stay of the curtailment order?
No, because I didn't believe the curtailment order affected me because I'm not adjudicated. If I was adjudicated, I'd have a water master, I'd have meters, and I know that I don't affect the Shasta River.
Why file a petition for reconsideration if you don't believe that the curtailment order applies to you?
Going to object to the question. It calls for a legal interpretation.
Okay, so this potentially raises attorney-client communications. And Mr. Griset, you do not have to tell us about the discussions you had with Mr. Manassian or any other attorneys if you have any other attorneys. But subject to that, can you answer the question of why did you file a petition for reconsideration if you didn't think the order applied to you?
Well, because that way they could understand that it doesn't apply to us.
Okay, I think, Ms. Orris, I understand why you're asking the question, but this so clearly is going to invoke attorney-client communications. I think you should probably move on.
That's fine. Just a moment. Did you receive the State Water Board order denying your petition for reconsideration last month?
Yes. Not within the 90 days.
I understand.
Could I ask you why it took so long?
Excuse me, Mr. Griset,
I know, I can't answer. But I have
it's
lots of
it's
questions.
probably not fair, but Ms. Orris is not under oath and you're not allowed to ask her
I
questions.
know.
So,
I have lots of questions.
well, I'm sure you do, but we have to stick to our rules here. So
I
she
got you.
she gets to ask the questions. Go
I
ahead,
apologize.
Ms. Orris.
Let's see. Are you aware that the petition for the order denying reconsideration did in fact state that the curtailment order applies to your water rights?
Yes.
I'm going to object to the question calling for a legal conclusion. It also misstates the language of the decision on reconsideration.
So, Ms. Orris, why don't you read? I'm going to sustain the objection. Please restate the question in terms of asking him what his understanding is of what the order says. I think that will avoid the objection.
Sure. I'll actually change questions. Have you or your attorney filed any sort of challenge to the order denying reconsideration?
I don't believe, as of yet, I don't believe we have.
Okay. Are you aware that the statutory limit, well, actually, no. Let's see. Can we pull up respondent 6, page 3?
All right, Ms. Mullen, please display exhibit respondent 6. And let's go to page 1 first for a minute so we can all see what it is. All right, and now and just for the record, this is a letter from Mr. Manassian dated March 9, 2022 to Mr. Cervantes, and you may move to page 3. Please, Ms. Mullen, move to page 3. All right, so go ahead, Ms. Orris.
Do you recognize this document, Mr. Griset?
I get a lot of documents. I'm not positive. Yeah, the request, is it the request for the hearing? Yeah.
Yes, it is.
Yeah.
Can you read the name? Or can you actually, sorry, can you read the top of this page that starts with I?
I hereby request a hearing regarding the proposed administrative civil liability complaint.
Can you please read the name that's listed on this hearing request?
Stephen David Griset.
Is your father's name, George, anywhere on this hearing request?
No, but everything, our curtailments were all parallel. Everything was parallel, and his denial was stuck in the post office until past the date that he was going to request a hearing. Otherwise, I don't think there would have been any reason to not have them together. I mean, it's my name, and my dad's name is not on there, just to answer your question.
Thank you.
Mhm.
Can we pull up, I believe it's PT8, the curtailment certificate form?
All right, Ms. Mullen, please post PT8. We now have it on the screen.
Can we zoom out a bit?
Yeah, we're gonna. Okay,
Thank you.
tell us what you want us to zoom in on when you have the right part. My old eyes can't read this fine print, so we'll have
It's
to.
just in general, Mr. Griset, did you submit your curtailment certificate form for either of your water right IDs?
No,
Have you submitted any sort of exemption to the curtailment order?
Not yet.
Can I have just 2 minutes to consult with my team, Mr. Lilly, just to see if I have any other questions?
Yeah, why don't we, yeah, let's go, we'll take 4. We'll go till 11:50. So again, a reminder, don't log off, but you can mute.
Thank you.
All right, we're all back. So Ms. Ores, do you have any further questions for Mr. Griset?
Just one or two, I believe.
Okay, go ahead.
Mr. Griset, did you sell or distribute any water to other parties after you at any point after you received the curtailment order?
Yes.
That's all then. Thank you, Mr. Lilly.
All right, thank you, Ms. Ores. So Mr. Griset, I have a couple of follow-up questions. First of all, I just want to be clear on this. Ms. Ores asked you whether you or your attorney filed any challenge to the order on reconsideration. And I just want to make sure we're completely clear on this. So I'm going to restate the question. Did you or your attorney file any action in court challenging the order denying your petition for reconsideration or the curtailment order or the emergency regulations?
No, but it's no, not as of yet. It was still fairly, the denial of the reconsideration was still fairly recent. And the curtailment order, once we realized that the curtailment order allows water use on your overlying property, it really that was the biggest issue. And then but no, we haven't done it yet. I didn't even actually know that was we didn't know. I didn't really realize that was an option. There's a lot of stuff going on, and I didn't really it still could be a consideration.
Okay, I just wanted to know whether anything had been filed yet. So thank you for that clarification. All right, so Mr. Griset, I think you testified you started selling water to other people in 2016. Is that correct?
Yes.
And so what years then, starting in 2016, during what years have you sold water to other people where they've loaded up water trucks and conveyed it to other properties?
2016, 2017, 2018, and 2020. And then and 2021 is extremely limited. There was, for many factors, there's just, there was ordinances, it was basically, there was in the people who were filling water trucks were intimidated so bad by the county, they just basically left. And
okay. That's fine. I just need to know the years. And where are all the places where the water that you sold was trucked to and used?
Well, we're adjacent to, like I said, 1,600 parcel development, and I would say that's where the water was going.
All right. Did all of it go to lots within the Shasta Vista subdivision?
As far as I know, we don't keep track of where the water goes. It's just, I'm assuming but I can't say for sure because I never follow the trucks.
All right. And then you mentioned 2021, but obviously now we're in 2022. So when was the last time you sold water to anyone who trucked it off your property?
In October of 2021.
Okay. So you have not sold?
No, that was the end of my irrigation season.
Okay. So you have not sold any water in 2022?
No.
Okay. And for the years you mentioned 2016, 2017, 2020, and 2021, can you give an approximate number of how many truckloads of water you sold in each of those years?
No, I have no way of knowing the exact number. I mean, we have, not off the top of my head.
Okay, well, I'll just say, like, was it more than 100 per year? More than 100 truckloads per year?
Yes.
Or was it more than 1,000?
I don't know. I don't know for sure, but
right.
More than 100.
Okay. More than 100 in each of those years?
I'm not sure, probably. I mean, I'm not positive.
Okay. And how much, I know, well,
I object to the question unless you ask how many gallons to a truckload. Yeah,
that was going to be my next question. So I don't think it's an objection, Mr. Manassian, but let me ask the question and you can tell me whether you want to object. Approximately how many gallons are in each truckload?
There's the big trucks are 4,000 and the smaller trucks are 2,000. And then once in a while you get somebody with a small truck, smaller, but yeah, mostly 2,000 and 4,000.
And can you give me a rough proportion, like whether it's half of each or whether it's more of the 4,000s or more of the 2,000s?
Probably half of each.
Okay. And what is the price either per gallon or per truckload that the buyers paid you for the water?
1 penny a gallon.
Okay. And then separate from trucking water, when was the last time you pumped the Griset Farms wells for irrigation of your own lands?
They're pumping right now. I began the irrigation season in March for a few days because of the dryness. Then I ran it for probably 10 days in April. And then now I'm irrigating right now. I'm irrigating, spreading the water over about 600 acres right now.
Okay. All right. So Ms. Mullen, can you please put up exhibit respondent 3? And Mr. Griset, if necessary, first of all, are you familiar with this petition for reconsideration that Mr. Manassian filed on your behalf?
Yes, I don't have it memorized, but yes, I know we send it in.
Okay. Do you know whether anything in this petition makes the argument that Mr. Manassian now is making that the pumping of water from your wells was all authorized by overlying rights?
Say that again, I'm sorry.
Do you know if this petition, anything in it makes the argument that all of your well pumping was authorized by overlying rights?
I'm not sure you made that argument, but I can't say for sure that argument's in there.
Okay. Well, and I understand it's a long document, so we'll read it. All right. So Ms. Mullen, please take that down and put up exhibit respondent 6. Which may be a new one, I'm not sure. Can you go to the first page of this, please? Okay, thank you. So, Mr. Griset, are you familiar with this letter that Mr. Manassian sent to Mr. Cervantes on March 9, 2022?
Yes.
And do you know if any, or does anything in this letter discuss the argument that Mr. Manassian now is making that the pumping of water from your wells is authorized by overlying rights?
No. No.
All right. And now, Ms. Mullen, if you can display, let me just see here. I think I already have covered that. Yeah, covered that. Can you display exhibit respondent 8? And go to the first page. So, Mr. Griset, are you familiar with this letter that Mr. Manassian sent to the State Water Board on March 30, 2022?
Yes.
And do you know if anything in this letter makes the argument that your pumping of your wells is authorized by overlying rights?
I don't. No, I don't believe it. I can't see the bottom of it, but I don't believe was the argument. It's. I think.
Okay, well, yeah. Go ahead.
Common. I mean, it's just common knowledge. That's where we use all our water. So.
All right. Do you know when either you or Mr. Manassian first advised the State Water Board that you were contending that the pumping of your water and all of the uses of that water were authorized by overlying rights?
No, because it's in the wording of the curtailment order, so we didn't think it needed, I didn't see the need to explain it to them.
All right. So let me look at, okay, so Ms. Mullen, can you please display the file we looked at earlier, which is the State Water Board Resolution 2021-08-17. And its resolution number. You've got it. Thank you. And please scroll to PDF page 26. All right, that's good. So Mr. Griset, I'm going to, first of all, are you at least generally familiar with these emergency regulations that the State Water Board adopted for the Shasta River watershed?
Yes.
All right, so I'm going to just read paragraph A and then subparagraphs 1 and 2. Paragraph A states, all water users or water right holders issued a curtailment order under this article are required within 7 calendar days to submit under penalty of perjury a certification of one or more of the following actions taken in response to the curtailment order, certifying as applicable that. And number 1 says diversion under the identified water rights has ceased. And I understand why you would not certify that because you're still pumping the wells. Number 2 says any continued use is under other water rights not subject to curtailment, specifically identifying those other water rights, including the basis of right and quantity of diversion. So why didn't you submit a certification to the State Water Board stating that your pumping was pursuant to overlying rights?
Oh, that's a good question.
All right.
Guess we went with the reconsideration because I had never heard the term water rights applied to an individual well owner ever in my life until I got this letter of curtailment, to be honest with you. Water rights, in my mind, were always surface water. I farmed my whole entire life. So it was, the whole thing was so confusing. And we went with the reconsideration as our action.
Okay, is it fair to say you relied on your attorney to decide what to do in that regard?
Yes.
All right. Thank you, Mr. Griset. I don't have any further questions. So, Mr. Manassian, do you have any redirect questions you'd like, basically following on the questions Ms. Ores asked and the questions I asked?
Yes, I think there's one line of questioning that would help the hearing officer understand this situation.
Okay, please proceed.
Is the main road serving this 1,600 acres of 2 and 5 acre parcels immediately adjacent and through a portion of your ranch, Mr. Griset?
Yes, for more than a quarter mile, at least more than a quarter mile, the people in the subdivision have a 60-foot easement through my dad's property. And then his property also has an easement through the subdivision through 2 sections for the installation and maintenance of a water pipeline.
Okay. Are you informed that at the time of creation of this subdivision by Siskiyou County officials, that a portion of the land that you're farming and the Shasta Vista subdivision were owned by the same developers?
Yeah, I'm positive that it was the Martin family did the development. They put the well in, and they actually owned the land where I farm also in the past.
Is it the way your system of irrigation is set up? Are all the delivery pipes to the pivots basically connected to the wells so that the system is pressurized by the well pumps themselves?
Yes, the whole entire system is pressurized from the wells, and it covers approximately 2.5 miles of farmland, different spread over the pipeline spread over 2.5 miles.
When a representative of the Hmong families comes to you and asks that they can take water, does your irrigation system have to be operating to irrigate lands that you're farming?
Relevant?
Yeah, it's a
Wait. Excuse me, Mr. Griset. What is the relevance, Mr. Manassian?
I just want you to understand the volume that's involved here, which is very small.
I don't know whether you're going to get there, but I will give you leeway to ask a few questions to try. So I'm going to overrule the objection and go ahead and see if we get there.
Let's go back to 2016 to 2021. Do you ever allow anybody to take water from the well at times in wells at times when you're not irrigating your land?
No, that would be impossible.
Okay. I have nothing further.
All right. So, Ms. Orris, do you have any follow-up questions?
No, I do not.
All right. So we have some exhibits. We have exhibits respondent 1 through respondent 12 now, with 12 being the certification form that we added today. Mr. Manassian, do you want to offer those exhibits into evidence?
I do.
And Ms. Orris, do you have any objections to any of these exhibits?
We do to respondent 9, 10, and 11 on grounds of relevance. They're discussing issues that are not relevant to this hearing. As you mentioned earlier, the case, I think it's respondent 9, is the case that applies to the county of Siskiyou. 10 is communications with officials of Siskiyou County, again, irrelevant to the State Water Board's actions. And 11 is a technical memorandum that is, there's just no relevance. It doesn't matter what basin Mr. Griset's farm is on. He didn't file his form.
Mr. Manassian, what is your response? I think you probably have different responses for each of these exhibits. So please, let's start with, we'll take them one at a time. What is your response regarding the argument that exhibit respondent 9 is not relevant? And that's the U.S. District Court order.
We believe it to be relevant because the effect of the order to file something with the state board is vague and uncertain when you take it into context with the fact that the federal district court has found that there is a pattern of discrimination against the Hmongs going on. So the court has to have, the hearing officer has to know what was going on in regard to the service of water from wells in the Shasta Basin, including Mr. Griset's at the time of the purported compliance order.
Okay, I have a real problem with how this is relevant for the reasons I've previously discussed. I mean, our hearing issues have to do with the board's actions not the actions of Siskiyou County, and we don't have any link between the two. I previously said if you think there's some, I don't know whether cooperation or concerted effort to enforce the ordinances that involves the state board staff, and I don't think there's any evidence of that. But if you think that's the case, I think the U.S. District Court is the forum for that. So I don't see that Exhibit Respondent 9 is relevant to any of the issues for this hearing. So I'm going to sustain the objection to 9 and not allow that into evidence. So Mr. Manassian, what is your response to the objection on relevance grounds for Exhibit Respondent 10?
All right. Now, I have to reserve my right to request that the hearing officer continue the hearing to allow Mr. Ekdahl to be brought in to testify on that issue.
All right, that's a separate issue from whether or not Exhibit 9 is relevant, and we'll get to that. But now my question is, what is your response to Ms. Ore's objection to Exhibit Respondent 10?
10, the notice, September 10 notice, and the curtailment order clearly says the order does not apply to overlying groundwater use. There is nothing in the regulation adopted by the state board that gave rise to the compliance order, which states that if you sell water or you charge for the water, even though it is utilized on overlying lands, that somehow the order kicks back into effect and you must file some sort of form on the internet. So we have the September 10 letter clearly says that this order does not apply to overlying groundwater use.
Excuse me, Mr. Mazin, I think you're talking about Exhibit Respondent 11. That's the Larry Walker report. My first question is Respondent 10, which is a collection of letters from your office to various officials in Siskiyou County.
That's right. And I was addressing 10.
Okay, I'm not getting it. How are these letters, which incidentally nobody's authenticated, how are they relevant to our hearing issues?
We're explaining to the hearing officer that we communicated with Shasta County and we provided copies of these letters to the State Water Resources Control Board. They were attached to the communications to the Enforcement Division, explaining that overlying use of groundwater on the adjacent Shasta Vista subdivision was an overlying use, albeit for domestic purposes or for cultural purposes by those landowners.
All right, so I'm going to sustain the objection to Respondent 10. I don't see anything in any of these letters that indicates that any copies were sent to anyone at the State Water Board or that there's any connection with the State Water Board's action. So I'm going to sustain the objection on relevance grounds. Now, what about Exhibit Respondent 11? That's the Larry Walker report. What's your response to Ms. Ore's objection to that exhibit?
It's relevant because it determines where the basin lands are and the lands overlying the basin.
Okay. I think Respondent 11 is relevant to the overlying rights issue that you have raised. So I'm going to overrule the objection and allow Exhibit Respondent 11 to be received into evidence. However, I will note the following. This contains, excuse me, this contains out-of-court statements by people who are not testifying, clearly as hearsay. So it's subject to the limitations on admissibility in Government Code Section 11513 Subdivision D. And so I will allow it into evidence subject to that limitation. I also will note that its relevance may be limited because I don't think there's anything in this exhibit that shows where the Griset Farms wells or the Shasta Vista subdivision or the Griset lands are. So I'm not sure I can use it for much. We do have this description of the boundary of the basin, and apparently there was a boundary modification action. And we have Mr. Griset's testimony about the Shasta Valley Basin. So I'm going to admit the exhibit, but subject to the limitation on use of hearsay, and also to the with the notation or the noting that I'm not sure it has, it has large probative value. So with that, other than that, so exhibits respondent 1 through 8 and 12 and respondent 12 are received into evidence, and respondent 11 is received into evidence subject to the limitations I just stated. Exhibit respondent 9 and exhibit respondent 10 are not received into evidence. All right, so Mr. Manassian, now we get to the question of your subpoena to Mr. Ekdahl, which apparently has not been served yet. And I think you've alluded to asking for a continuation of the hearing. Is that correct?
Well, I don't know how far we have to go on this. Clearly, if the hearing officer concludes that the notice was inadequate to alert that some sort of filing had to be made, even though overlying groundwater use was not subject to the curtailment order, then we don't need to get into what the origins of this act of putting an identification number on certain groundwater users was, and whether or not that act complied with the emergency regulation, because somebody put on the condition that if you're receiving money, somehow that made it an appropriative water right. So I'm inclined to think that this is resolvable by the hearing officer without that testimony. But if that becomes significant as to how it was that certain groundwater users in the area of the Shasta Valley became subject to an identification number and a compliance order, and others didn't, then that issue has to be brought back into the evidence at some point.
All right. So first of all, I'm not in a position today to tell you or anyone else how I'm going to rule on the hearing issues, because I haven't received your briefs and I haven't reviewed all the evidence, and I don't know how I'm going to rule on the hearing issues. So I can't give you some assurance that I'm going to rule in a certain way and therefore evidence may or may not be relevant. So frankly, from what I'm hearing, I think what you're saying is you think it may be relevant to have somebody from the State Water Board staff testify as to how, I'm just going to say, the list that's at the end of exhibit respondent 1, it's on pages 7 through 10 of respondent 1. That's the list of all the water right IDs, the ID numbers, names of what they call primary owner and priority dates. I think, Mr. Manassian, what you're saying is you think it may be relevant to have somebody from the State Water Board staff testify regarding how they developed that list. Is that correct?
Yes, but just the first 8 or 9 names on that list are in question.
Okay, well, frankly, if we're going to get into that, I think it's important to know how the entire list was developed. I'll just be candid. If we get to the amount of civil penalty issue, assuming we get that far in the process, in the decision-making process, and I don't know whether or not we will. But if we do, I mean, I would like to know whether this list is comprehensive or not. I mean, I've heard arguments that it may or may not be comprehensive. So here's what I propose. Before I propose something, though, I'm going to let Ms. Ores talk. I've obviously raised something she wants to address. So Ms. Ores, your hand is up. Go ahead.
Yes, this appears to go to the issue of how and why this curtailment order was issued to Mr. Griset, to the respondent. And in the recent ruling, the HO's ruling on May 10th, on the last page, it says, issue 1 for the present hearing concerns whether or not the Deputy Director of Division of Water Rights issued a curtailment order, respondent, not why. And this is going to the issue of why. I feel like we've clarified that that's not the issue here. It's just, did he comply?
I don't, okay, I mean, there's some nuances here. And that is the ruling, and I'm not in any way questioning that ruling that Ms. Matnai has made. But I think, I mean, now we have some evidence that neither she nor I had when she issued that ruling. And that in particular is this list. I'm holding up respondent 1, page 7, this list of all of these water right IDs. And one of the factors under Water Code 1055.3 is the nature and seriousness of the violation, and I think some of the other factors may apply as well. And to me, it is relevant. I don't think these questions of whether there were certain motivations by Siskiyou County people are relevant to this hearing, but whether or not the board's list is comprehensive or just includes some of the water users in the Shasta River watershed, to me, is potentially relevant. So here's what I'm going to propose, and then both of you can respond. I'm going to propose that I will give time for Mr. Manassian to send a subpoena. I don't think you need documents. I think part of the problem with the prior request for documents is it was very broad and potentially would have been very burdensome for the Division of Water Rights to comply with. But I think we've now narrowed it down enough. What we really want is just the person most knowledgeable to answer the question or questions regarding how this list was developed. So what I propose is that I give Mr. Manassian leave to send a subpoena, and we do have the provisions from the Code of Civil Procedure, which I think will apply here, that can be the person most knowledgeable. It can be Mr. Ekdahl or the person within the regulation development team who has knowledge. Frankly, there may be somebody who has more knowledge than Mr. Ekdahl. But the person most knowledgeable within the Division of Water Rights regarding the development of the list that is on pages 7 through 10 of respondent 1. I think that's the only thing that we need to pursue further, but I think Mr. Manassian has raised enough of an issue that he should be allowed to pursue that. So first I'll ask you, Mr. Manassian, if I give you leave to serve such a subpoena, and you'll have to figure out how, because I don't have any connections with the Division of Water Rights on this, but if you can serve a subpoena on the Division of Water Rights to that person most knowledgeable, and that person then can testify at a continued day of this hearing, will that satisfy your concerns about this issue?
Yes, I think it would. It seems to me the court could address the threshold issue. If you give a notice and you say the overlying landowner use of water is not subject to this order, doesn't that mean it's not subject to filing anything on the internet, especially when you look at this form, which has.
Okay, I think that's really, at that point, Mr. Manassian, you're getting into things you can address in your closing brief.
Okay. I will put a most knowledgeable subpoena out.
All right, so and we'll ask about scheduling another hearing day. So Ms. Ores, I understand you've made your objection on relevance grounds, which I've overruled. But considering that, do you have anything further to say about this proposed process for moving forward?
Yes, I just feel that this was covered in the order denying reconsideration. This is just another way to get at and go around a question that has already been decided at the State Water Board.
Okay, you mean decided in my office?
By the board itself, with the order denying reconsideration. It's already decided that this order was properly served upon the respondent, or actually not just the respondent, but also George, because the petition was made on behalf of both Stephen and George.
All right, well, it's a little hard for me to know for sure how this is going to play out on relevance grounds because I haven't developed the proposed order yet. But I think at this point, I want to give Mr. Manassian and Mr. Griset the benefit of the doubt, because I think this potentially could be a relevant issue, particularly on the amount of any administrative civil liability, assuming, and again, I haven't decided, but assuming my proposed order concludes that any administrative civil liability should be imposed, this may be relevant to the amount. And then, of course, this is all subject to whatever the board decides to do with my proposed order. So subject to those caveats, I think this could be relevant. So today is May 19. 2 weeks gets us to June 2nd. Again, this is, you can just, if you serve the subpoena to person most knowledgeable, that person doesn't have to prepare any documents or anything. So it seems like we should be able to do this, that person ought to be really ready fairly promptly. And I assume, Mr. Manassian, you're capable of getting a subpoena to the State Water Board in the next day or two. So how do people's calendars look for having a continuation of the hearing for that very limited purpose on June 2nd? I'm going to say at 9 o'clock in the morning.
That's fine with the respondent.
And Ms. Ores, how does that look on your calendar?
That's fine for my calendar as well. I would like to request that that should a subpoena be issued, that someone from the Office of Chief Counsel is CC'd, as they would be the attorneys for Eric or whomever else who would be served.
Well, I certainly expect somebody from Office of Chief Counsel to appear with the witness. I don't know that it's my job to tell the division whether or not Division of Water Rights staff that would receive the subpoena, whether or not to go to Office of Chief Counsel. I think that's up to them to decide. So I'm not going to require that. I suspect that if they get a subpoena, they will contact Office of Chief Counsel, but that's really their decision, not mine. So let's go ahead and put this down. Well, first of all, I've got to ask my staff. I get into trouble if I set a hearing for a date that one of my colleagues has set another hearing on. So Mr. Anderson or Ms. Blunk, can you just check our calendar? Are we free to do a hearing in the morning on June 2nd? I'm afraid to close this window and open my calendar because I'm afraid I'll crash or accidentally log off of this.
Mr. Lilly, the AHO's calendar is open on June 2nd.
Okay, thank you, Mr. Anderson. So we'll go ahead and schedule it for then, and it's just for that very limited purpose, one witness on just these issues of how did the I think it was called Regulation Development Team, developed this list. And particularly, certainly, how did they decide to include George Griset and Stephen Griset on that list? And frankly, I'd also would like to know why there are no priority dates listed for those entries and for a couple of the others. So I actually, I'll tell you, I was planning to ask Mr. Cervantes these questions, and obviously he doesn't know, so he can't answer. So I think this is important. So anyway, that's the plan. We will discuss the schedule for closing briefs and the issues to be addressed in closing briefs at the close of that hearing on June 2nd. I am pretty sure this will not take 3 hours. It should take a lot less than that, but we will set it for 9 to 12 on June 2nd. And I will send out a supplemental notice of hearing just to confirm that. So are there any questions regarding that plan? And of course, we'll do this by Zoom, just the way this is. I think, well, go ahead, Ms. Orris, go ahead.
Just asking that in the supplemental hearing notice that you'll list those issues that you will be limiting the hearing to.
Okay, I think that's reasonable. And the other thing I'll list, I think we'll use the same Zoom contact information, but if there's any change, I will include, or my staff will include that in the list so we can all log into the right place. All right, so is there anything else we need to cover today? Hearing nothing else, we'll move on. I mean, we'll close, but thank you all. I just want to say, I know these issues are very serious to all of you, and that you have, clearly have very differing views on them, and I understand that. And I just want to say I appreciate the fact that everyone conducted himself or herself in a professional manner today, and I really appreciate that. I think it really facilitates the hearing process and certainly for my decision-making process. So thank you all very much in that regard. And with that, last call for anything else, or we're going to sign off, and I will see you all on June 2nd at 9 a.m. All right. Thank you very much and have a good day. Goodbye.
Thank you, Mr. Lilly.